When can schools be legally responsible for failing to address peer-to-peer sexual harassment? What's in the new 2024 Title IX regulations? Can we go just one episode without talking about Florida?
Yeah. Honestly, you call yourself the Sunshine State, you should probably call yourself the Headline State.
That might be more appropriate, though. That makes me think of Florida Man. Do you know Florida Man?
I do not know Florida Man.
So type in Florida Man into Google with your birthday.
Okay.
And you'll get some fun headlines about, speaking of headlines in Florida.
All right, I'm going to try this. Florida man arrested after trying to cross Atlantic in hamster wheel vessel.
What?
Florida man leaves shoes outside overnight, discovers dozens of millipedes the next day.
Yeah, so speaking of Florida headlines.
Florida man claims to be Captain America, had meeting on base.
Oh, well, hey, I wouldn't mind that.
This is, okay, I'm going to spend way too much time looking at this now. Thanks a lot, Chris.
We have a podcast to record, Jamie. Let's focus in.
All right, let's see. So today we're going to talk a little bit about Title IX. We're going to talk about sexual harassment. We're going to talk about the new regulations that were released last month. These new regulations expand and clarify Title IX's protections and provide schools with flexibility in responding to allegations of discrimination or harassment. We'll also talk about a big Supreme Court case on peer-to-peer sexual harassment from the late 1990s that helped pave the way for lots of action in this area over the last few decades. This is the case of Davis versus Monroe County Board of Education, not in Florida, this is Georgia actually. The case of a fifth grade student who reported being repeatedly harassed while the school allegedly did nothing for months.
Mm-hmm. Welcome to Chalk and Gavel, where we explore how the law shapes education one case at a time. I'm Chris Thomas. I've been a high school English teacher and a school attorney.
And I'm Jamie Cudlitz. I've been a middle school math teacher and principal. And now we're both professors of educational leadership, working to empower folks to better understand and navigate the laws that profoundly impact our schools.
This is the show that tells the fascinating stories connecting the courtroom to the classroom.
Talking Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
All right, so we kind of gave this away already, but Chris, what is our bell ringer about today?
Yeah, so we've got new Title IX regulations. So these are new regulations. They were officially published at the end of April, but we've known about them since mid-April. And these new regs do some really important things. So they are the Department of Education's interpretations of Title IX. And the new regs expand protections for LGBTQ plus individuals and essentially say that they are covered under Title IX in really important ways. And the new regs also roll back some of the changes that the Trump administration made in 2020 when they adopted regs that required some really specific and burdensome procedures for schools to go through in order to address allegations of sexual harassment or discrimination. So these new regs are a really big deal.
Yeah, and I think one of the reasons why they're such a big deal, because like you just said, you've got every administration kind of just rolls out these recommendations, right?
Mm-hmm.
And one of the and so like what makes this one different? One of the reasons why this one is different is because there are different degrees, right? There are different ways that you can interpret Title IX.
Mm-hmm.
And what happened this time around is they went through a much more detailed, extensive process.
Exactly.
Right?
Mm-hmm.
That essentially...
It ensures that these new regs have the force of law behind them.
Yeah.
And that's something that has not been true for a lot of other kind of interpretation guidance documents that the Department of Education has put out over the years. So, Title IX, the Obama administration said that Title IX protected LGBTQ individuals, but they did it through a Dear Colleague letter.
Right, which is just a pretty sort of less formal way. They're basically just saying, here's what we think Title IX should be about.
Exactly.
And, if you want to go ahead and follow these guidelines,
that'd be great.
Follow the guidelines. We'll leave you alone. If you don't want to follow those guidelines, we might try to have a beef with you.
We're not saying you'll be breaking the law. We're just saying we're not going to be your friends at that point.
Yeah, exactly. And so a lot of that has happened with Title IX. And I think Title IX is such a small statement, right? It's only 20 some odd words or something like that. And so over the years, since 1972, it's really been interpreted, or it's had to be interpreted.
Right.
What does this mean, right? So a lot of it has to do with athletics, right? And sort of, ensuring that at least when the law came into being in 1972, a lot of that was sort of happening in the midst of women's athletics, for example, at the high school and collegiate level. They didn't have the same facilities. They didn't have the same opportunities. They didn't have the same resources and equipment and whatever. And so, Title IX was designed to kind of start leveling the playing field, to use the athletics
pun intended.
But beyond that,
right,
there have been a lot of opportunities for different administrations to come in and say, all right, well, in this particular instance, this is how Title IX would work. And in that particular instance,
right,
and we're going to talk a lot about sexual harassment today, right? That wasn't sort of such a big thing in the 70s. After it, that became more of a Title IX thing in the 80s and 90s.
Under the law, let's say.
Under the law, right? Yeah. And so, so I think one of the reasons why what just came out is so big is because of the process that it went through, right?
Right. Yeah, as you were saying, Title IX, pretty short, right? It just kind of essentially says that no federal fund recipients like public schools or colleges and universities can discriminate on the basis of sex in their programs or activities. That is incredibly broad.
Yeah.
And so, every administration has kind of said what that means in certain situations and in certain contexts. But yeah, here we've got new regs. And just to kind of put it in perspective, these regs are the culmination of a 2-year process that the Biden administration's been going through. And so in order to get new regs that have the force of law, you have to go through a very time-intensive process. You've got to put out notice. You've got to get public comments. You've got to respond to those public comments. And you've got to publish, your response that kind of addresses all of the comments and how you change the regs based on public comments. So it's this massive undertaking.
Yeah.
And so in this case, they got over 240,000 public comments, which means that the final regs responding to all those comments that got published in April was over 1,500 pages.
Wow.
Yeah.
That is a lot.
I haven't read that many pages since the last Harry Potter book came out.
Yeah. Listen, and that's why you're seeing lots of stuff in the news right now about all these states that are suing the Biden administration over these Title IX regs.
Including...
Hey, Florida.
There it is. All right. We met our quota.
Yeah, we're about 5 minutes in, and there's your Florida headline, folks. Yeah, so these are really big. And so, like you said, these codify the scope of sex discrimination and include language that ensures that schools won't discriminate based on sex stereotypes, based on sex characteristics, based on pregnancy or related conditions, based on sexual orientation, gender identity. All of those things are in these new regs, right?
Right. Yeah.
So a much broader kind of scope of protection.
Right. And that's why all these states are now kind of bringing these lawsuits. So the last time I looked, beginning of May, there were 15 states at least that had brought 4 lawsuits already against these regs, because these regs directly contradict a lot of state laws
Yes.
and local policies that, basically prohibit transgender individuals from using the restroom consistent with their gender identity.
Yeah.
And so
Interestingly, it doesn't deal with those private spaces, bathrooms, athletics. Those are apparently forthcoming, right?
well, no, it does deal with bathrooms. It doesn't deal with athletics. So these regs are, they have the force of law. We've mentioned that. And Title IX, the regs say themselves, when there's a conflict between Title IX and our regs versus state law, our regs, the Title IX regs, take priority. So these new regs say that basically not treating individuals consistent with their gender identity subjects them to discrimination under Title IX. And so the preamble to the regulations, within those 1,500 pages, right? They talk about how this applies to restrooms and locker rooms. It applies to accesses to classes and activities, and it also applies to dress codes. So schools under these regs have to treat individuals consistent with their gender identity when it comes to which restrooms to use, which locker rooms to use, which classes to go to, which dress codes to enforce against students.
Right. Now, I will say, just to give a few examples here. So, for example, the courts have found that separating certain classes by gender, having gendered math classes and things like that in certain circumstances, as long as you do it the right way, that's okay to do, right? So what these regs are saying basically is if you have somebody who identifies as female in a situation like that, the school would be required to allow that student to attend the female math class. Right?
Correct. Yeah.
So it's not just about bathrooms.
Right. Yeah.
And dress codes too. And we've talked about this in some bell ringers and our first case, if long hair, we've had issues where males cannot have long hair.
Right. Which probably violated Title IX before these regs anyway.
Right. But these regs make it even more.
Right.
That's why there's a lot of states right now who are challenging this because it goes against what they're doing.
Right. And it supersedes state law to the contrary. And that's big. So, we've talked about that rock and that hard place, right? Between federal civil rights law and local state laws. So I guess we're going to exceed our quota, but that the Florida teacher who was let go for using gender neutral pronouns, right? We've talked about how that school was kind of between a rock and a hard place between federal Title VII and then state laws that seem to contradict that. Same thing is true here. But, these regs are very protective of LGBTQ plus students. So not only do they say that treating them in ways that are inconsistent with their gender identity constitutes discrimination, but the preamble also mentions that schools can't require students to submit to invasive medical inquiries or burdensome documentation requirements to establish their gender identity, because asking them to do that when you don't ask other folks to do it would impose a harm on those students, and that would constitute sex discrimination. And so there's a lot of things in these regs that, really kind of work to ensure equal access for LGBTQ plus students within these educational programs and activities.
Yeah. And I would say reading through them as well, in addition to the strengthening of these protections, right? There's also a significant degree of procedural guidelines and safeguards, right? To ensure that these investigations and processes or whatever are fair, are objective, are appropriate, right? And, just reading through some of these things, all schools must treat complainants and respondents equitably, right? There can't, whoever's doing the investigation can't have a conflict of interest, and they can't have a bias for or against either the respondents or complainants in general or as individuals. And so, it also outlines the sort of presumption of innocence. Right.
And that's something that I think these regs do a really nice job of, is they establish these protections and then, to talk about kind of how they address the process of enforcing all of this, right? They do a really nice job of balancing giving schools flexibility with maintaining everyone's rights within the process. And that was kind of So that's in a direct response to the 2020 regs that came out during the Trump administration, because they set out a very rigid process that required schools to jump through a lot of hoops before they could enforce Title IX. And the whole purpose of those regs was to kind of correct an imbalance that the Trump administration saw for basically how people accused of sexual harassment were treated versus how the alleged victims of sexual harassment were treated.
Right.
And these regs, like the 2024 regs, they keep a lot of the stuff, like the let's call them substantive protections from the Trump 2020 regs, but they do so in ways that allow a lot more flexibility.
More flexibility and and ensure that they are applied equally.
Mm-hmm.
Yeah. So this is big stuff.
Mm-hmm.
We're still waiting on the the more specific athletic guidance.
Right. They only received 140-ish thousand comments on the athletic guidance. So I anticipate that's not going to take 2 years, maybe 18 months.
Yeah. Oh, we were thinking though that because of the election coming up, that they might just wait to put any of this stuff out. So I don't think on April 18th, any of us knew that the next day these things would be dropping, right?
Or 2 Taylor Swift albums.
Exactly, right? Now, we saw that one coming. She teased that at one of the award shows.
Not that it was a double album.
It sure wasn't 1,500 pages worth of lyrics.
No, it wasn't. I got through that a lot quicker.
So these things came out, and it's the tortured educators department. Title IX is hard, folks. That's all we're trying to say. Title IX is hard. It's hard. It's hard just because these kinds of issues are really, really complicated and
personal.
Yeah, these are people's lives, right?
Right.
And and this stuff is not easy. So hopefully, at least what the goal of these particular regulations, what the goal is to kind of provide schools with more information to navigate these really complex and challenging situations.
Right.
Right. And it's partly in part because the courts are all over the place with this stuff.
Right.
They're all over the place.
And now that we've got the regs, everyone has to follow the regs.
Right.
Until the regs get challenged.
Right. Which is happening. Right. It took just a few days before states started filing lawsuits, and it's honestly I can't tell you how many are in play right now. It's in the teens at least, but by the time this episode comes out, it could be different because I can tell you 2 days ago when I was doing some research on this stuff, there have been more states that have signed on to these things in the last couple of days. So this is going to be drawn out, and I wouldn't be surprised if some of this stuff makes it significantly through the system, because the courts are going to have to wrestle with how all over the place the courts have been with this, right?
Right. And it's going to be affected by how the court decides the Chevron case and whether or not, or basically how deferential courts are going to be to administrative regulations now.
Yeah. So basically the short version there, and I'm going to totally oversimplify this, is
we would never.
The Chevron case basically, and again, big oversimplification here, is on one end of the spectrum, you've got a law that Congress passes, right? And on one end of the spectrum, the law is what it is. And if it's not specifically written in that law, there's nothing you can do. On the other end of the spectrum, you've got a law that's written and passed by Congress, and then there is some deference left to the agencies that have to sort of deal with that law, so to speak, or who are affected by that law. They are given the ability to interpret aspects of that law and say, okay, this is what this thing means, this is what that thing means, and this is how this should get applied. And the Chevron case is sort of wrestling with how much authority do those organizations have, right?
How much authority should courts give them?
Oh, should courts?
So basically, how much deference should courts give them when these agencies interpret these statutes?
Got it.
But yeah.
So this is one of those examples of, the agency has interpreted Title IX.
Right.
And the Chevron case, the outcome of the Chevron case could determine how much of that is allowed.
Right. Because the Title IX, the text of Title IX just say, you can't discriminate on the basis of sex.
Right.
And here we've got this regulation that says, we understand on the basis of sex to mean all of this other stuff because it's all wrapped up into that phrase.
Right. On top, again, it's not just about the sex phrase that's in there, right? Like there's, it says, school programs and activities. Well, what does that mean? It has been interpreted by these agencies to include pretty much everything that a school can do. So it applies to field trips. It applies, everywhere, right?
Right.
And then there's...
It also applies to sexual harassment.
Exactly. And then there's the sort of clause in there that is about receiving federal financial assistance, right? Which in the last few years has been interpreted by the courts in a number of different ways, right? So for a while, it was like, listen, if we're a private school, we don't get federal money, so Title IX doesn't apply to us, right? But there have been a couple of court cases in the last few years that have determined that certain tax-exempt statuses that private schools have, right, would count as receiving federal financial assistance. And so therefore, you have to abide by Title IX. But then there was another case that went the other way. And so, this Chevron case is going to have a big impact on this and a lot of other things. Anyway.
That was a great way to explain how complicated Title IX is.
Yeah, so sexual harassment was not such a huge component of Title IX for a while, right? Like it's there, but it didn't really come into the forefront of the Title IX conversation, say, until the late 80s and 90s, right?
Right.
And there were a handful of cases that kind of pushed that topic with respect to Title IX to the forefront. And the Davis versus Monroe case.
Yeah, I think let's talk about Davis, and then we can talk a little bit more about the new regs and how they might apply to a situation like this moving forward.
Right. Yes, because the Davis case started in 1992. It was ruled in 99. So obviously happened all before these new regs. Right.
Ultimately resolved in 2001.
Right.
9 years later.
Yeah.
When LaShonda is now in college.
Right. And all of this took place when LaShonda was in 5th grade.
Right.
So, yeah. So the justice system is speedy here.
What is it? The
wheels of justice. Is that it? The wheels of justice turn slowly.
Well, that's the one. And then there's also the long arc of justice, or the long arc of the law bends towards justice. Is that? I think I was mixing metaphors.
Oh, yeah.
The slow wheels of justice bend toward law.
All right.
We'll cut all of that.
Play with that, listeners. Okay, so let's talk a little bit about what happened in the Davis case. So we are in 5th grade in 1992 in Monroe County, Georgia, south of Atlanta.
Were you in 5th grade in 92?
No, Chris. I was in 92. I don't know, 9th or 10th grade.
Okay.
Yeah.
I think I had just entered elementary school. So that means the student here is like right between our ages.
Oh, great. Where were you? Kindergarten? What'd you say?
I think I would have been 5. So probably kindergarten.
Okay. So we've got a 5th grade student. This is LaShonda and her mom. Everything's happening. LaShonda and her mom are on one side of the equation here. So according to the complaint by mom, we have a situation of harassment that started in December of 1992. Okay. In LaShonda's class was another student, don't know their name. The initials are GF. Okay. And according to the complaint, GF attempted to touch LaShonda's breasts and genital area and made vulgar statements, things like, I want to get into bed with you. I want to feel your boobs. Okay. Those kinds of statements were made in December of 92, allegedly.
And the school immediately responded, shut it all down,
and
addressed it appropriately.
Thanks for listening. We'll see you next time. No.
Yeah. A 27-minute episode wouldn't be bad.
No. Our listeners would not be that lucky.
Sorry, listeners.
So that happened in December, and it continued. Okay. More of the same was reported to have happened on January 4th of 93 and January 20th of 93 And each of those times, LaShonda reported those incidents to her mother and to her teacher.
Okay.
Mom also contacted the teacher, who allegedly told mom that the school principal was aware of those incidents.
Okay. So not only is the student doing what she should be doing by, telling authority figures, but then mom also kind of follows up.
Yeah. And is basically told by the school, the principal is aware of these situations, which, if I was a parent, I would say, okay, the right people know.
Mm-hmm.
I'm going to assume those right people are going to do what they need to do.
What they should be doing, which
Right.
unfortunately, these facts make me really mad.
Yeah, well, it gets better. So that was sarcasm, folks. It doesn't get better. It gets worse.
It gets worse for everyone.
Yeah. So apparently nothing happened to GF and the conduct kept happening.
Mm-hmm.
In early February, GF apparently placed a doorstop in his pants and proceeded to act in a very suggestive manner towards LaShonda during PE.
These are fifth graders, right?
These are fifth graders.
Okay.
But again, LaShonda reported that behavior to the PE teacher. Okay.
So that's a different teacher too, right? So now we've got at least 2 teachers who know about this stuff.
Right. About a week after that, so we're still in February here, still stuff going on, but this time it was with a third teacher present.
Oh my gosh. Okay.
And the incident was reported to that teacher. And in that situation, mom contacted the teacher to follow up again. All right.
And still nothing.
According to this complaint, nothing had happened at this point.
Okay.
Okay, now we're in early March in PE class again. It's still going on. LaShonda reported the additional occurrences to 2 teachers, to the PE teacher and another teacher. So we've got multiple teachers being told on multiple occasions about harassment from this one kid.
Right.
Now we're in mid-April. GF allegedly rubbed his body against LaShonda's in the hallway. According to LaShonda, it was done in kind of this sexually suggestive manner. Right. It wasn't just like, I bumped into you. Right.
And that means that the behavior is escalating, right? There's not been a response here. And things kind of seem to be getting
physical,
more frequent and more physical, more serious, right? Because there hasn't been a response from the school.
Right. So, and again, all of these things were reported according to LaShonda and her mom, and nothing stopped according to them until mid-May, when you're going to love this, Chris. Well, I know you're going to love this because I know you know it already because we both read this case, but this stuff only stopped when GF was charged with and pled guilty to sexual battery.
Right.
So the parents had to, or the mom, essentially somebody.
Yeah. Called the cops, asked them to press charges.
Yeah. And they did.
Yeah.
And he pled guilty, and then everything stopped. Okay.
Yeah. So that good on those parents, right? I think that if the school's not doing anything, it's still going on. There's all these negative things going on with LaShonda because of all of this. Good on them for trying to find solutions. It's also kind of tragic because you've got this 5th grade kid who, the school could have stepped in earlier. They could have addressed this behavior. Not saying that the school has control or could have stopped it, right? But if they had done something other than nothing, maybe we never get to the point where this student now has pled guilty to a criminal offense. And LaShonda hasn't gone through months and months and months of this harassment. It's one of those things where it's I obviously want to cheer that, some justice has been done, but it's also kind of sad at the same time.
As to how long it took and at what cost and whatever, but you're doing a lovely job of setting up these these new Title IX regulations.
Look at that.
Unfortunately, this took a toll on LaShonda. So according to the complaint, LaShonda really suffered during those, 5 months of harassment. Her grades, which were high at the start of this, were dropping. She was becoming unable to concentrate. And in April of 93 of that year, her father discovered that she had written a suicide note. At one point, she told her mom that she didn't know how much longer she could keep this kid off of her. And it also came out that LaShonda wasn't the only person that GF was harassing, that there were other girls that were recipients of his harassment.
Mm-hmm.
And at some point, a group composed of LaShonda and other students tried to speak to the principal about this kid's behavior. All right. And even though they tried to, they were kind of denied the opportunity by a teacher who responded to them and said, if the principal wants to talk to you, he'll call you, basically.
Oh my gosh.
Right?
I know this is an audio medium, and so you can't see me shaking my head in just
Yeah, he's shaking his head a lot.
Disbelief, I guess.
Yeah, no, it's pretty amazing here. So, there were other things where, the principal is reported to have stated in response to the mom saying, what are you going to do about this? The principal is reported to have stated something like, well, I guess I'm going to have to threaten him a little bit harder.
That was it?
Yeah, well, it doesn't seem to have a lot of substance to it, does it?
No.
So another thing that really shocked me about this was that it's written in this court document that it was only after more than 3 months of reported harassment that LaShonda was allowed to change her classroom seat so that she was no longer seated next to GF. So I'm reading that.
That floors me.
And I'm like, okay, this kid has continually indicated to the teacher and other authority figures in the school that they're being harassed, that there's behavior coming from this one particular kid
towards LaShonda,
right? And I mean, listen, moving kids' seats is one of the easiest things you can do.
Right. And even just take the sexual harassment component out of this, keep your hands to yourself, right? The very first thing you do is you move the kids, right?
Right. And
I cannot fathom how this took 3 months.
And not just that, but you know what? So you move kids when they're talking too much, because they're great friends. You move kids when they don't get along really well. And you know what? It's a much easier problem to solve to just have them sit in different spots, right? It's just not a hard thing to do. But between December and March, when she moved seats, when she was allowed to move seats, the number of instances that she reported, it wasn't just 1 or 2, it was 5, 6. Anyway, so that's what led to a lawsuit.
And this is one of those situations where I think we can all see why they filed suit, right?
It makes sense to me.
Yeah. And so maybe we should have mentioned this sooner, but the facts that we have come from the family's complaint. We actually, really, the facts are only their side of the story. Because the case gets decided so early in the process, the district actually never has a chance to tell its side of the story because, they moved for summary judgment and won it. And so, we've got these facts, and yes, they're very egregious. Maybe we need to take them with a slight grain of salt that it only tells one side of the story. We're not sure exactly what the school side of the story was because the case never got that far. So the family files this lawsuit in May of 1994, so about a year after all this had kind of wrapped up. And the lawsuit alleged that the board is subject to Title IX and that by allowing the persistent sexual advances and harassment by GF towards LaShonda, that interfered with LaShonda's ability to participate in school, and it affected her performance in her studies and activities. And that deliberate indifference violated Title IX.
Now, that's an important thing to sort of talk about with respect to Title IX, right? Or at least to highlight, right? You can't just claim sexual harassment or discrimination, right? You have to be denied educational opportunity or access, right?
Right. Yeah. So Title IX says, you can't be discriminated against on the basis of sex, denied the benefit of blah, 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 in any program or activity, right? So you have to be denied something.
Yeah. Now, that could be as simple as LaShonda's grades going down, right?
Mm-hmm.
Like what's happening to LaShonda is depriving her of her ability to access.
Right.
Right?
Yeah, it's very similar to like hostile environment discrimination,
Mhm.
right? Like you've created this climate, this environment, or you've allowed this environment to continue that is making it, I'm less welcome. I feel less safe. I feel less belonging. Therefore, all of this stuff, I can't get the same educational benefit as others. And it's all because of my sex, because that's the foundation for the harassment, right? And that's kind of that's the theory that LaShonda and her mother, Davis, are bringing in this lawsuit. And so we've got this lawsuit, and this is a really novel claim. Courts had not, or at least the Supreme Court had not addressed this question of peer-to-peer sexual harassment yet. They had addressed a question of teacher-to-student sexual harassment, but not when this lawsuit was filed. That didn't get decided until 1998. So like this is 94. There's still a lot of stuff unknown at this point.
Yeah.
And because of that, the district, the defendant here, files a motion to dismiss the complaint. They don't even answer the complaint. They just file a motion to dismiss and say that essentially, even if everything that Davis and LaShonda is saying is true,
we didn't do anything wrong.
There's no remedy under law because you can't establish that any law was broken. So this is, I think we mentioned it before, this is a 12b6 motion for failure to state a claim upon which relief can be granted. You don't need to know any of that, but it's just fun to toss out legal terminology like that. And so when evaluating one of these motions to dismiss, you have to kind of assume everything said in the complaint is true, because you're basically looking to see if the well-pled factual allegations of the complaint could plausibly give rise to legal liability. So basically, even if I accept everything you're saying is true, did the defendant still do something legally impermissible?
Right.
And the trial court grants the school's motion. And the trial court says that Title IX provides no basis for liability absent an allegation that the board or an employee of the board had any role in the harassment.
So they're basically saying Title IX only deals with the adults in the school doing the harassing.
Right.
And because this was a student-to-student thing, Title IX, that's not part of it.
Yeah.
That's fascinating.
Basically, it said that the school doesn't have responsibility because it's not the school doing the harassing, right? And that's actually what the 11th Circuit says too. So this gets appealed up to the 11th Circuit, and initially the 3-judge panel of the 11th Circuit reverses and says that, just like Title VII allows for liability when you allow a hostile work environment to be created by your employees, so too does Title IX ensure that schools have an obligation to respond to peer-to-peer sexual harassment.
Because it's creating a hostile environment.
Very similar, right?
Yeah. So they reversed that.
But
the district didn't want that reversed. So
they appeal it, or they ask the 11th Circuit to review it en banc.
Yeah. Which again,
speaking of fun legal words to say.
Yeah. So en banc is just when the entire panel of judges.
The entire court.
The entire court. So all of the judges that sit on the 11th Circuit, which again is a Florida.
Could be about a dozen.
That's Florida's part of the 11th Circuit.
Man.
Look at that. Here it is.
Okay.
But yeah, that's when, because usually these cases, when they get to that level, they're heard by a panel of like three of those judges. But en banc means all of the judges are going to hear the case.
Right. Yeah. And so the en banc court ultimately sides with the trial court and again affirms the grant of the motion to dismiss.
Yeah. So again, they agree that because an adult in the school didn't do the harassing, that the school's not responsible.
And the reason they do that is because of this little thing in the Constitution called the spending clause. And so
It's always about the money.
It's always about the money. So the 11th Circuit en banc reasons that because Title IX is a spending clause statute, which essentially means that Congress passed it and offered states and schools a lot of money. And as part of taking that money, they had to agree to certain conditions like not discriminating based on sex. And so there's this idea within spending clause legislation that when you give people money with strings attached to it, you have to be very clear about what the strings are. And so the 11th Circuit en banc basically says that it's not clear from Title IX that schools would be on the hook for peer-to-peer sexual harassment. And so because it wasn't kind of unambiguously stated, we're not going to create new liability for schools because they didn't know that's what they were getting into when they accepted federal money.
Wow.
Yep.
That is like, well, it just feels like such a technicality in light of what happened in this particular case.
Right.
Right. I get it, but
obviously I agree with how the 5-4 Supreme Court ultimately comes out. But to kind of like, I guess, articulate some of the considerations about the spending clause, like we want to make sure that the federal government, a government of limited authority, doesn't kind of usurp state authority or, the rights held by the people. And so there's a lot of issues of federalism at play here where if we have this limited federal government, if that's something we value about kind of the separation of powers between our different systems of government or different layers of government, then we have to respect that and we have to put bounds on what the federal Congress can do. Right. And so that's ultimately kind of what the dissent kind of comes back and says, like, that's their big concern. Obviously, the majority shares that concern, but balances the interests a little bit different.
Yeah, no, that makes sense. Yeah.
Yeah. And so this gets appealed to the Supreme Court, and the Supreme Court in a 5-4 decision. So again, Jamie, going back to that, you said it's really close, right?
Yeah.
Justice Sandra Day O'Connor writes the majority opinion and reverses the 11th Circuit. And I just have to say, Sandra Day O'Connor is a good writer. She's a good writer because in the introductory paragraph of her decision,
she nails it, huh?
She lays it out, right? Like she just says, hey, we're here to consider whether or not a private damages action can lie against a school board in cases of student-to-student sexual harassment. And we answer, yes. We conclude that a private damages actions may lie, but only where the funding recipient acts with, and these words are going to be so important, deliberate indifference to known acts of harassment that are so severe, pervasive, and objectively offensive that it effectively bars the victim's access to an educational opportunity or benefit.
Right. And that, in that one paragraph, right?
Right. Like that's the takeaway.
She defined how we evaluate what we use to deal with sexual harassment to this day. Right.
Right.
And but I don't know about your classes, but like, any of my classes, that paragraph is going to really, really resonate because they've heard over and over again, deliberate indifference, severe, pervasive, objectively offensive, like that's language.
Yeah.
Thank you.
Right.
Justice O'Connor.
Yeah. Well, and Justice Kennedy writes the dissent, and he kind of like pokes at all of those and says, hey, all of those are arbitrary lines and they're really ambiguous and we don't know where the lines are.
Oh, come on. Honestly, like the courts are so
which
good
is kind of,
that's what they do.
Right. And that's their job. It's also funny because it's Justice Kennedy and he has a reputation for writing flowery, ambiguous decisions.
Well, that's my point. Like there's tons of language that the courts use all the time that is subjective and, like
you could almost argue that language itself is always subjective. And
well, there you go.
Subjectivity is inherent in language. But I think that might be getting a little too philosophical.
Yeah, that's for a different podcast.
I'll host that one with you. What do you say? So the majority opinion starts to discuss Congress's spending clause power. And so, thinking about Congress or the federal government as being one of limited authority, they see spending clause legislation. That's one of the things in the Constitution that the federal government has authority to do. It can pass laws that basically like give a ton of money to states and other entities. And if you take that money, you have to agree to certain conditions. So it's kind of like a contract. And the court even says like, it kind of makes sense to think about this as a contract where if you want my money, here's what you got to do to get it.
Yeah.
It's kind of a carrot and a stick. The carrot is here's a ton of money. The stick is, and here are the strings attached. And so in order to kind of be appropriate spending clause legislation, the court says that you have to provide adequate notice. And the majority finds that Title IX provides adequate notice because, so the terms of Title IX essentially protect the victims of sexual harassment and discrimination. It doesn't say kind of like who needs to be doing the protecting, right? So thinking back to the language of Title IX, it says that no person shall be subject to discrimination.
Yeah, it doesn't say no person shall be subject to discrimination by a person in authority or by, the agency or whatever, right? It's victim focused rather than responsible party focused.
Right. It focuses on the protected class.
Yeah.
And so the school, kind of come back and argues that Title IX doesn't provide notice to schools who accept money that they're going to be liable because it makes schools responsible for other people's actions, not their own actions. And, it seems unfair, right, to kind of like hold one person responsible for something that somebody else does.
Mm-hmm.
And they say like, it's not fair to hold us responsible for third parties who we have little or no control over.
But O'Connor's statement addresses that.
Yeah. She says, yeah, no, I agree.
Mm-hmm.
The only problem is I'm not holding you accountable for what other people do. I'm holding you accountable for what you are doing.
Or
school,
not doing.
Or
Right.
not doing.
Exactly.
Exactly.
Yeah.
And also, you have control over students, right?
Yeah.
Like that's kind of the definition of schools.
Yeah, no, exactly. I mean, and it's argued in a lot of other cases, the courts have given you that authority.
Right.
To
And
control.
recognized its importance, right?
Uh-huh. Uh-huh.
Yeah. And so that all kind of, undercuts the school's argument, and the Supreme Court comes back and says that, yes, school, we are going to hold you accountable, but we're only going to hold you accountable, not for the things that other people do. We're going to hold you accountable for your response.
Yeah.
When you know about it. And that's the big thing here is like, we are holding schools accountable for the things that they do or their deliberate
Indifference. Yeah.
inaction,
Inaction.
right? Like deliberately indifferent is the standard that the court articulates here, which basically just means, did you act in a manner that was clearly unreasonable under the known circumstances?
Right.
Because if you acted clearly unreasonable, then the discrimination at that point kind of falls on your shoulders.
Yes.
Because now you failed to stop it.
Yes.
When you could have stopped it, right? And that's kind of the whole logic of the Supreme Court's opinion here.
Mm-hmm. Yep. And that makes perfect sense. So the Supreme Court kept, remanded it, and it was remanded and remanded and remanded, right?
Right. We talked about the ambiguity of language, right? But there's those three terms that we have to kind of think about.
Mm-hmm.
What level of harassment? Severe, pervasive, and objectively offensive, right?
Right.
That's kind of a squishy term.
Right.
There's also the question of deliberate indifference. Like, it obviously means clearly unreasonable, but what's clearly unreasonable responses when you're responding to that sort of stuff? And then the third one is like this question of notice, like who needs to know about the harassment?
Mm-hmm.
It has to be in the employee to student sexual harassment context. It has to be somebody who has the authority to correct the situation. In student to student, though, almost all employees of the school have some authority over students. And so like that's something that the court actually kind of leaves open, is this question of like, who needs to know about the harassment?
Right. And that's something that our Title IX regulations
Regs address, right?
Yeah.
Yeah. Yep.
So wherever LaShonda Davis is right now, her case did quite a bit.
It did. It set the stage for the next 20 years, right?
Pretty much. Yeah. And so what they did basically was they kicked this back. They didn't necessarily answer the question of did the school do wrong or not. They were basically just saying, under what circumstances would we consider the school doing wrong? Right. And so what they did was they kicked it back down to determine whether or not in this particular case, the school was wrong in light of the parameters that the Supreme Court identified, right?
Right. So it gets kicked back to the 11th Circuit. The 11th Circuit kicks it back to the trial court, and the parties ultimately settle in 2001. 7 years later. A long time.
A long time. Well, I mean,
LaShonda was in college at that point.
9 years after the events.
And we don't know what was in that settlement because it is confidential, which I want to know.
I know.
But yeah, so taking it back to the new Title IX regs. So we kind of talked about how Davis set the stage for these regs. And so Davis makes schools responsible for responding to peer-to-peer sexual harassment. The new Title IX regs kind of tell you how to respond in ways to ensure fairness and to ensure, that everyone within the process their interests and rights are protected.
Right.
And so that's a big part of these regs. It was a big part of the regs that came out in 2020. And so, if we were applying the 2024 regs to the Davis case,
then they really messed up.
Oh my gosh. Yeah. No, they got Title IX violations left and right. So the new regs say that schools have to respond to allegations of sexual harassment promptly and effectively.
So they have to, when they become aware of something, they have to. Now, respond, it does not necessarily mean discipline somebody, right?
And that's a huge distinction within these regs because you have to, before you discipline a student for allegations of sexual harassment, you have to go through a very, very specific procedure.
Mm-hmm.
But as soon as you have knowledge, and the regs are very clear that like every single employee of the school has to report suspected sexual harassment or discrimination to the Title IX coordinator immediately. Like no questions asked. Every single person has to report.
Right.
And then at that point, you can offer supportive measures. You can, work to address the discrimination, though you cannot engage in punishment until you go through the process. But that doesn't mean you can't separate them. That doesn't mean you can't put them in different classes. It just means that you can't suspend or expel a student because of allegations of sexual harassment.
Until you've done the investigation in a very sort of prescribed, objective, with the right people who have had the training and all that.
Exactly.
Right?
Based on the right policies and all of that. Yeah.
Yeah. And so basically what you're doing there is you're basically saying, all right, as soon as you become aware of something, you've got to act. You've got to put the sort of system in motion. Right. And if you can do that, right, and you can go through these procedures, sort of hypothetically speaking, if your investigation, if you do everything by the book and your investigation goes one way and you find out that, the situation does not warrant any sort of disciplinary action, and then somebody, again, this is hypothetical and there's a lot of details missing, but like if you do what you're supposed to do, then what all of this basically says is if somebody challenges you from a legal standpoint, you're protected because you did what you needed to do and you did it in a timely way. You acted when you became aware of something. It's when you don't act, when you have become aware of something. It also means like if you're not aware of something, how can you act on it?
Yeah, and we're not going to hold schools accountable for the things they don't know.
Exactly.
Right? The flip side of this whole conversation is also true. Like just because you have to go through these procedures before you discipline a student doesn't mean that Title IX says you have to be passive, right? Like Title IX actually says the opposite. These new regs say the opposite, where as soon as you know about this stuff, you have to respond effectively. You have to provide supportive measures. You have to do a lot of different things. You can only punish someone. You can only take punitive actions if there's a complaint and if you go through this complaint process.
Yeah.
But, I don't want any school administrator to feel handcuffed by these new regs because honestly, these new regs are so much more flexible than the old regs.
Right.
And I don't want them to think that they can't address sexual harassment because I don't want them to kind of be stuck between that rock and a hard place again where I can't be deliberately indifferent, but I also can't do anything until I go through this process.
Right. And which is not the case, right? You can definitely do stuff. You just can't suspend somebody or you can't, you can move their seats. You can take all kinds of actions, and because one of the things is, if you've got an allegation, you have a responsibility to protect everybody, right? And so you have the ability under these new regulations, you have the flexibility to do what you need to do to ensure that everybody is supported and protected while you go through that process. So yeah, that's that.
I like the ending, and that's that.
And that's that. Yeah. So, I mean, again, we only skimmed the surface here, right? In the last hour.
Right.
On Title IX and the new regs and where all this stuff came from and the Davis versus Monroe case and all of that stuff. We really only wanted to kind of give you a little bit of a sense of what all this is about and sort of where it has come from. I'm sure that there will be a number of other cases and bell ringers, especially bell ringers, as these lawsuits play out, right? Where we will get into the weeds on a lot of these different angles, much more. But for now, that was a little bit of a primer, right? A little Title IX primer.
Yeah, an entire episode too on one topic. I don't think we've done that yet.
No, but I think it's okay. It's all good.
No, I liked it. I think this might be my favorite episode so far. We'll see. We'll see.
It's a bold choice, my friend. That's a bold choice. Yeah. So, listen, lots of good stuff coming up. Lots of great cases. Chris and I are putting together an educator's guide for the show that'll come out eventually.
So excited for that.
Yeah, we've got the Education Law Conference that's coming up in November, where lots of us are going to be together talking about all of this stuff.
In sunny Orlando.
Florida. There's
another
Florida again. Yeah, so lots of cool stuff coming up, and we hope you keep listening. So, Chris, give us our homework.
I think you pretty much covered it. So
Excellent.
Find us wherever you find your podcasts. Follow us on social media. We'd love to hear from you. Let us know if you've got ideas for cases, for bell ringers, or if you just want to talk about anything school law. We would love to continue the conversation.
All right, folks. Well, that does it, and we'll see you in a couple of weeks. Have a good one.